So here's a question. How invested do you have to be in the commission of a crime to be held criminally culpable? In other words, if you're just the driver in a getaway car and someone else is responsible for doing the dirtiest of deeds or pulling a trigger or what have you, are you still on the hook for the whole thing? And if not, how much? So, welcome. This is a video case overview of the State v. Gonzalez case from the Supreme Court of Kansas from 2020. So, it's a relatively recent case. We're recording this video in December of 2021. So, it's not too long ago that this case was litigated. And it involves some of the many questions that I asked at the onset as we began. So, an individual who was complicit, certainly, in several crimes, but the questions here all hinge around how much, right, and what kind of culpability there is appropriate. And so we're going to take a look at this case and how it unfolded, ultimately culminating in a criminal conviction appeal, which is what the Supreme Court of Kansas was hearing with this case. And we're going to look at how they ruled on the various issues and why. So here we go. So there's a little bit of background on the Gonzalez case, some facts here to help familiarize you with what happened here. So, beginning with sort of the first interactions or encounters with law enforcement, a car with a description matching Gonzalez's car was first stopped in a traffic stop by law enforcement for suspicious behavior and a noise violation. So, this was kind of the first contact that law enforcement had with Gonzalez on the evening in question. Now, at that point, Gonzalez had actually fled the scene of the stop and evaded capture. So he had gotten away for all intents and purposes at this point. But just a few moments later on the same evening, Scherzer, the victim in this case, was shot in a bar in an apparent attempted robbery. Though, interestingly, the victim's wallet was never taken. Right? So there were valuables that were left on the body, which would lead an investigator to think that perhaps it wasn't a robbery, right? If you conclude that someone is assaulting someone for the sake of taking their valuables, you'd think they'd actually take the valuables. And if they don't take the valuables, you might conclude otherwise. You might think that this was some type of targeted assassination attempt or some other type of malicious act, a murder for a purpose other than just incidentally occurring incident to another crime like a robbery. So that's worth mentioning as part of the context of the case. A car matching Gonzalez's was also connected to the shooting. So there were, some witness reports and I believe some evidence that led police to conclude that the same car that was in the traffic stop and the same car that belonged to Gonzalez was also on the scene of the shooting of Scherzer. Later that day, that car that matched the description was found to belong to Gonzalez, in fact. So we're back to the Gonzalez car as we discussed earlier. And a trail of blood led from the car to Gonzalez's house, right? So there's this culmination of evidence leading in the conclusion that, Gonzalez probably had something to do with the Scherzer shooting. Right? So Gonzalez was also treated for a gunshot wound on the same day, right? So this is all sort of coming together in one big smoking gun in terms of what happened and how it happened. And frankly, the facts of the case in terms of the crimes that were committed are not really in dispute, even by the defendants, those that are accused of the crime. So they're not disputing what happened and who was involved, but the extent to which Gonzalez was involved in this is what's really called into question: his mental state, the intent that he had in participating in the act, and how things unfolded and whether or not that was part of the plan, right? That's really what the crux of this case is all about as we move forward. So just keeping that in mind, that, Gonzalez isn't really disputing that he wasn't there, right? That he wasn't present for the shooting or for the traffic stop earlier. None of that really is in contention. What's in contention is what role Gonzalez played in all of this, because he wasn't alone, as we're going to discuss in just a moment, and what his intent was, because as we'll discuss, some of the criminal charges and the convictions center around specific intent crimes, and that's really important here. So the prosecution's evidence against Gonzalez, what are we talking about here? Well, initial analysis showed that Espinoza, who was the accomplice in the crime, right, was Gonzalez's buddy or mate in the car, was actually the one who fired the shots that killed Scherzer. Right. So we have evidence to believe that Gonzalez was not the one that actually fired the gun that killed Scherzer. Perhaps Gonzalez was driving, or Gonzalez was just present at the time. But Gonzalez didn't actually pull the trigger, right? So this is just something to make a mental note of as we move forward in our analysis of the case. The only evidence indicating that Gonzalez intended to rob Scherzer were text messages indicating that Gonzalez was seeking to quote unquote get paper, right? So there was some text messages between Espinoza and Gonzalez indicating, something to the effect of "Let's go get this paper." And so one of the questions that's pivotal in this case is, what in the world does that mean, right? And so if you're familiar with street lingo, you may have some intuition as to what it means. But what can you infer from that, right? When you're talking about getting paper, are you automatically implying an illegal act? Or are you just implying something that is intended to earn money or get cash or acquire cash, right? So the police detective in the case was permitted to testify about the meaning of this text message. So the detective testified at trial that in his experience, getting paper means getting money at all costs, including robbery, right? So this testimony was permitted to include this sort of interpretation that says, yeah, it means to get money, but without sort of limitation as to how, right? So to up to and including criminal behavior. So that was testimony in the criminal trial. Gonzalez's text messaging also referred to Espinoza as his teammate, right? And this is important in more than one of the criminal charges and convictions, including conspiracy, which we'll talk about earlier. So again, make another mental note and pin that up as, text message indicating Gonzalez referring to the partner in his car as his teammate, right? So the prosecution used these facts as evidence that Gonzalez and Espinoza had conspired to and attempted to rob Scherzer, and thus Gonzalez is liable for murder, even though Espinoza was seemingly the person who pulled the trigger. So we have this sort of joint effort, and there's an attempted robbery that perhaps was botched. It's unclear exactly what went wrong or how it went wrong. Maybe Scherzer resisted, or maybe something didn't quite go to plan. But because you have a complicit attempt through two individuals, they're both being charged with more or less the same offenses in this case. And it's worth noting at the onset, because some of this hinges around Espinoza's involvement, that Espinoza had originally pled guilty and was convicted, but then was appealing the conviction and seeking to recant the guilty confession, the plea, and that comes up insofar as Espinoza plays a role in Gonzalez's trial, which is what's really the focal point of our discussion tonight, is focusing on Gonzalez's appeal, right, and before the Supreme Court. We're not concerned with the conviction of Espinoza for the sake of this conversation. We're looking at Gonzalez's role, the convictions, and what he was trying to seek having overturned by the Supreme Court in this particular certiorari review. So Gonzalez offered testimony that he had consumed marijuana and Xanax, which, possibly a number of things here come into play when you call into question your mental state and your coherence, indicating a partial defense of voluntary intoxication. Now note the key word here being voluntary, because voluntary intoxication is not normally a defense to any crime. Insofar as, if you voluntarily intoxicate yourself and then do something that causes damage or harm to another person, you can't claim that you're innocent of that act. Unlike if you were involuntarily intoxicated, that is to say, if you were poisoned, or roofied or what have you, and you went on to do something outside the scope of your coherent ability to resist, that would be a different circumstance. But if you voluntarily intoxicate yourself, by drinking yourself stupid, or ingesting illegal drugs, or even legal drugs, right, which would cause you to be incoherent and do stupid things, that will never be a defense to the act of the crime. But what it could do is negate the intent element, right? And insofar as in this particular case, we're talking about several crimes that have a specific intent element, right? That means that in order to prove those crimes beyond a reasonable doubt, the prosecution has to prove that the charged individual, the accused, had the intent to commit the crime, right? And so if Gonzalez can show that through his intoxication, voluntary or otherwise, he lacked the intent necessary to commit a crime, then he could potentially overcome the charge of that crime by virtue of the fact that the intent element is missing, right? So that's where this comes into play. It also could serve to explain why the conduct possibly could not have been a robbery, which again, would require the purposes of it's a theft by force, right? So was that the intent that he and Espinoza had upon their encounter with Scherzer, right? So Gonzalez also called Espinoza to testify as to his intoxication, and this is what I alluded to earlier. But Espinoza pled the fifth and refused to testify. So, on the grounds that he could self-incriminate and that his testimony might be damaging to his own case, he refused to participate in the Gonzalez trial. And so this is one of the things that is called into contention by Gonzalez on appeal. Because among other things, Gonzalez says, well, look, if Espinoza had been forced to testify within limits that would not have violated his Fifth Amendment rights, he might have been able to say things and offer things that would have exonerated Gonzalez, or at least reduced the amount of liability that Gonzalez faced for the crimes that he was charged with. So this is one of the many things we're going to be talking about over the course of this discussion. So the verdict in the appeal, ultimately at the trial court level, Gonzalez was convicted of felony murder, which, if you're not familiar or you don't recall, felony murder is a murder that occurs incident to the commission of really any other felony. So in this case, we're talking about robbery, right? We're talking about an attempt to rob somebody, which by all accounts and the factual evidence appears to have been botched. It doesn't appear from what we see that there was an intent, premeditated attempt to murder, although I will disclose at this point that Gonzalez was also charged with premeditated, aka first degree murder. So there was an attempt to make that charge stick. It ultimately did not. So Gonzalez was not convicted of first degree murder. What he was convicted of is felony murder, which is, again, it seems quite clear there was an attempt to commit a robbery by both Gonzalez and Espinoza together. This culminated, whether intended or not, in a murder. And felony murder doesn't require specific intent to murder. It just requires the idea that a murder is foreseeable, right, under the circumstances, as we'll talk about when we review, the felony murder qualifications and requirements here. It just requires that murder be something that is foreseeable on the part of the parties that commit the felony. Right. So if you're going to commit a felony like a robbery, which is theft by force with a deadly weapon like a gun, is murder a possibility that you should be able to foresee in that context? If the situation goes wrong, right? If the confrontation turns south, is that something that could happen? Of course. Is it foreseeable? Absolutely. Right. So felony murder only requires that element of foreseeability. It doesn't require that you have intended to kill anybody. In fact, by definition, felony murder is sort of absent intent, because if you did intend to kill somebody, you'd be guilty of probably a more severe degree of murder. Again, that first degree premeditated murder. We also have attempted aggravated robbery, or aiding and abetted in an attempted aggravated robbery, which is part of the charge here, because Gonzalez was, again, complicit in that act with Espinoza. And the attempt element is a specific intent crime. So we'll be getting to that. And conspiracy to commit aggravated robbery, right? So one of the things you may be asking yourself as we're going through this right now is, what is the difference between conspiracy and attempt? And are these redundant or in some ways overlapping? And I will sort of foreshadow that that's one of the claims that Gonzalez makes, is that these are redundant, that they amount to double jeopardy for the sake of, double charges for the same crime, and that he should not have been convicted of both, although he was. And so we'll talk about how the Supreme Court reasoned as to that claim from Gonzalez, that they essentially overlap each other and amount to the same thing. They don't, as a little bit of a spoiler there, but we're going to find out more specifically why, according to their definitions, why they're different charges, different crimes, and different convictions. Right. So Gonzalez appealed on the following grounds. And what were those grounds? First, Gonzalez said there was an insufficiency of the evidence to support the convictions. In other words, there was not enough evidence to find a guilty plea, even though Obviously, the trial court level ultimately found him guilty. The attempt and conspiracy charges duplicated each other. So again, I talked about that just a moment ago, but this is the claim that these are redundant in the sense that it's not fair to charge and convict him with both for the sake of punishment. Um, the court made erroneous aiding and abetting instructions to the jury, so the instructions that were given to the jury in deliberating were incorrect, legally speaking, and we'll talk about that claim. The court should not have permitted Espinoza to avoid testifying. So, in other words, another way of putting that is that the court should have required Espinoza to sit, should have forced Espinoza to testify to the extent that it doesn't violate his Fifth Amendment rights. And then finally, that the prosecution's peremptory jury strikes were racially motivated to remove Hispanic members from the jury. So Gonzalez is obviously a Hispanic individual, and the claim here from the defense is that the prosecution, each side normally has peremptory jury strikes, which essentially just means so many jury strikes that you can remove jurors from the potential pool of consideration without having to state a reason for that strike. So you can just deliberately say, number 2 is gone, number 7 is gone, number 13 is gone, and I don't have to articulate why I'm moving to strike that particular juror. And you usually only get so many of those in each trial setting. And normally any reason is acceptable. However, you cannot use peremptory jury strikes for racially motivated reasons for the purposes of racial discrimination. That is not permitted. And so if there's evidence or suspicion that you committed peremptory jury strikes for the purposes of racial discrimination, as Gonzalez is alleging, then there's a test, which we're going to look at in this video, that analyzes the purported reasons for those, the evidence to suggest that they might have been racially motivated or racial pretext, and then we'll get into what that means for the court's review. So these are the reasons that Gonzalez is up on appeal, and now we're going to take a look at these individually and deliberate, whether or not they hold water under the circumstances. So on the attempt charge, first thing to note, again, as I mentioned earlier, attempt is defined at law, generally speaking, and state statutes may vary a little bit, but this is sort of the most common definition generically. Any overt act toward the perpetration of a crime done by a person who intends to commit the crime but fails in the perpetration thereof, or is otherwise prevented or intercepted in executing such crime, right? So attempt is by definition an unsuccessful crime, right? If you commit the crime, you will not be charged with attempted murder. You'll be charged with murder, right? So if you fail to commit the crime, you have attempt, right? And so we're talking about attempted robbery because it does not appear, because Scherzer's wallet was still intact on his person when police discovered the body, that the robbery was successful or that it was completed. Now, whether or not Gonzalez and Espinoza were intercepted or interrupted in the commission of the crime, or whether they just simply failed for other reasons is unclear. But the bottom line is they didn't complete that, but they certainly completed acts in furtherance of that, right? So any overt act toward that perpetration, right, in furtherance of committing it will suffice for the sake of attempt, right? And that's the key here. The attempt in this case was of aggravated robbery, which is an elevated level of robbery. And by definition here, knowingly taking property from the person or presence of another by force, right? This is what defines the difference between robbery and theft, right? Robbery is a specific type of theft. It's not sneaky theft where you break and enter and then steal something without someone's knowledge or steal something through deception. This is where you steal something by brute force, right? And it can be done by way of just physical strength and the simple threat of harm with the body. But aggravated robbery is threat of bodily harm committed by a person who is armed with a dangerous weapon and or someone who inflicts bodily harm on any person in the course of the robbery, right? So again, aggravated robbery is an elevated kind because you're doing that robbery with a deadly weapon, or you're also inflicting bodily harm pursuant to that robbery. Because you can imagine a robbery that occurs without any bodily harm, right? If I walk up to you and I say, give me your wallet or I'm going to punch you in the face, and you, out of fear for being punched in the face, give me your wallet, I walk away without incident. I never make physical contact with you. Well, now there's no bodily harm, and it's probably not an aggravated robbery because I'm not using a deadly weapon. But if I had that same encounter with you with a gun, right? If I pulled out a weapon and showed it to you and said, I'm going to blow your head off if you don't give me the wallet, well, yeah, that's aggravated robbery, right? On the other hand, if we go back to the original scenario and I'm not armed with a weapon, but I say I'm going to punch you in the face, you give me the wallet and I punch you anyway, right, on my way out to prevent you from sort of following me or chasing me. That's also a form of aggravated robbery, right? Because I've inflicted harm upon you pursuant to the crime. So these are kinds of the distinctions that rise, that elevate the level of the crime from a normal robbery to what we would call an aggravated robbery in this case. And this is an important focal point in the analysis of this case. Attempt is a specific intent crime, right? It's always a specific intent crime, which means that it requires subjective intent for the criminal objective. Not necessarily in all cases to commit the exact crime as purported with the exact individual. So, for example, suppose that you intend to murder person A, but you accidentally miss and shoot and kill person B, right? You're still going to be considered guilty as charged of murder. If you have a mistake of fact, for example, you intend to kill person A, but you don't realize, that by mistaken identity, you're aiming at person B, you miss, you may still be charged with attempted murder of person B, depending on the circumstances, even though you never intended to kill that person in the first place, because it's not as relevant that you intended to kill a specific individual as it is that you intended to commit murder, right? So that was the attempt, and there was no debating the fact that you intended to commit that crime. But without the intent element, you cannot have attempt, right? You cannot have an attempt to do something that you never intended to do in the first place. So the prosecution has an uphill battle whenever there's an attempt charge on the docket, because they have to prove that element of intent, that this is what you intended. And insofar as we're talking about this case, again, it's important to distinguish. We're not talking about intent to commit murder. We've already established that the crime here, although the prosecution did pursue premeditated murder, so there was an element of trying to prove that this was premeditated, that didn't stick. What did stick was the felony murder, which doesn't require intent, right? It only requires foreseeability. What we're talking about in the context of specific intent here is the specific intent that's necessary to satisfy the attempted robbery charge, right? The attempted aiding and abetting of a robbery charge insofar as Gonzalez is concerned, right? So that's the distinction here. And it's important to note that participation in the acts tending to lead towards the criminal result is not generally enough, right? So again, just because you're participating in the process, if you're not intending for a result, then you're not going to that's not going to happen, right? That you're not going to get there in that respect. So just participating in those acts that lead up to a criminal act will not be sufficient to satisfy the elements of intent for the purposes of an attempt crime, whether it's attempted murder, attempted rape, attempted robbery, attempted arson. Any attempt crime, by definition, generally speaking, is a specific intent crime, which requires that element of what we call the mens rea, right, or the guilty mind. So the defense argument, Gonzalez, of course, argued on this grounds that there was no evidence of intent. So Gonzalez says, look, I was in the car, but there was no intent for me to commit this crime, nor is there any evidence of that. There's no video, witnesses, evidence of a struggle, forms of communication that showed a plan to commit robbery, other than this cryptic text message we've been talking about of want to get this paper, right? So what does that mean? And so again, to the extent that that's ambiguous and open to interpretation, Gonzalez argues, the police officer, the detective that testified at trial about, this being get money up to and including through illegal means. Okay, but that doesn't mean that my intent was to do something illegal. It just means I'm looking to get money. It could mean I'm looking to get a job. I'm looking to earn money in some legal way. I'm looking to win money in a lottery or gambling, to the extent that it's legal to do so. So it doesn't necessarily prove to be a smoking gun. It doesn't say, want to commit this robbery. No, it says want to get this paper. And that can be interpreted in more than one way. So that's Gonzalez's main point on that subject. The defense argued that the evidence, insofar as the attempted robbery charge is concerned, is too flimsy. broad and ambiguous to support a conviction, and that the detective's interpretation represented mere speculation, right? So the defense is arguing that the detective is leaning into this and inferring things that he shouldn't be inferring about the nature of this text message, right? That doesn't amount to enough, or should not amount to enough to support a conviction. So, what did the Supreme Court of Kansas say in this regard? They said the cumulative evidence presented here in the case was easily enough for the conclusion that Gonzalez and Espinoza intended to rob Scherzer. Right? There's enough there to show that on the table. Intent, as the court noted, is usually proven by inference arising from circumstantial evidence. So what they're saying is pretty rare that you have a statement on record, something documented that clearly and unambiguously speaks to the accused state of mind, right? You don't often have a criminal who just before committing a crime, records a video or audio note of themselves saying, "I can't wait to commit this crime. I'm about to commit this crime, and I want to commit this crime," right? So what do you have in the absence of that, which is to say that it's almost always absent? You have circumstantial evidence, right? You have things from which you can sort of look at the totality of the circumstances and establish whether there's enough there to support a conviction. And that's really what we're talking about here. So direct evidence of a state of mind is very difficult to prove, again, unless you have that testimony as to the statement of the defendant. The testimony that the text message, again, quote unquote, want to get this paper, likely meant intent to rob someone, was enough to allow a rational jury to conclude that there was intent. And that's all that's required, right? So the Supreme Court doesn't have to Monday morning quarterback the discretion of the jury in their deliberations. They just have to be able to find that the evidence was sufficient for a rational jury to conclude that there was intent sufficient for the conviction that they delivered, right? That's all. They don't have to even agree with the conviction. They just have to find that it was rational on the basis of the evidence presented. So once there is a conviction, there's a presumption of guilt, which can be overridden only when the jury's decision is shown to be irrational, right? If you can't lead to that conclusion, if you can't say that, well, in light of the evidence, the jury acted irrationally, then your presumption is no longer one of innocent until proven guilty. You have a conviction. So on appeal, the presumption is guilt. And only if you can show that the jury was totally out of line in light of the circumstances and that no reasonable person could look at this evidence and arrive at that conclusion, that would be the only way to overturn something like this. And the court looked at the evidence, including the text message and whatnot, and said, no, this is in line with what would be fair under the circumstances, right? So the conspiracy charge. So as a reminder in terms of what conspiracy is and how it works under the letter of the law, conspiracy is defined as an agreement with another person to commit a crime or to assist in committing a crime, right? So it's a collusion between one or more individuals. It requires a minimum of two, but you could have 2 or 10 or 30, as long as you have some collusion between 2 or more individuals to do so. Formal agreement is not necessary. They don't have to sit down and sign anything, or draw out their plan on paper. It's simply enough if the parties tacitly come to an understanding, even if it's an implicit understanding, right, about the unlawful purpose, which can be, again, inferred from significant circumstantial evidence, right? So again, just as we talked about with mens rea, right, in the state of mind of a guilty party, which is difficult to infer, because we don't often have the objective statement, right, that's on record right before something happens. We also don't usually have objectively conclusive evidence of a conspiracy, because guess what? If you're going to commit a conspiracy to do something illegal, you probably don't want that kind of evidence. And so it's intentionally avoided, right? If you and I are going to collude together to steal something or to assassinate somebody, we probably don't want a written agreement that says that, right? So you're not going to find those in most criminal cases. What you may find is circumstantial evidence that suggests that there was an agreement, right? An implied agreement or some type of collaboration between the two of us for a common objective that is illegal, right? Some unlawful purpose. And that is what gets us to conspiracy, right? So in most states, including Kansas, at least one of the conspirators must undertake an overt act in furtherance of the conspiracy of the crime of conspiracy to apply. So again, as we mentioned earlier with attempt, you're seeing a similar vein here, an overt act, right? You have to do something. You can't just say, yeah, let's go kill that guy or let's go rob that store, and that's the end of it. That on its own, if nothing else is done, is probably not enough to substantiate a conspiracy claim, even if the crime is not committed. Now, if we say, you and I collude and we say, yeah, let's go assassinate, that guy over there, or our boss or whoever, and one of us goes out and purchases a firearm pursuant to the plan to do so, right? I go out and I buy a gun and I buy bullets for the express purpose of committing this murder that we just discussed. Well, now we have an overt act, right? Or if I plan something for lying in wait, right? We begin to review the sort of choreography of this crime, something that is overt, that moves the plan forward beyond mere discussion. That's all it takes, and it only takes one of us, right? Noting that it doesn't take everyone in the conspiracy to participate, just one person that goes beyond the component of mere speaking, right? Which is why it's so important not to speak, out of jest or sarcasm or insincerity anytime we're in a heated or emotional state. Because notice here that even if you said, with a friend or something, geez, I'd love to kill my boss or whatever, and your boss says, yeah, I'd love to do that too, let's do that, right? And you chuckle and brush it off, but then your friend goes off and buys a shotgun for the sake of moving forward with this, on the understanding, mistaken or otherwise, that you were serious, right? Now you have an overt act. And if someone were to find out about that, you might have a conspiracy charge, because you weren't required to go to the store and participate in the shotgun purchase. All you had to do was participate in the discussion. And then he went and took the overt act, right? And so this is why it's really important to maintain good decorum and not say things that we don't mean out of turn, because others can put us in legal jeopardy that way, as per the definition of conspiracy, right? So, the application of conspiracy to the Gonzalez case, insofar as this relates to, the facts of what happened here, the court reasoned the text message that he and Espinoza were teammates, right? When read in the light most favorable to the prosecution, were enough to allow the conclusion that they were engaged in an enterprise together. So, in other words, we talked about this earlier, that teammates text message, that in and of itself, according to the court, was substantial enough as an overt act to move the crime forward to satisfy the elements of conspiracy, right? That was sufficient. The text message that they were out to get paper could reasonably be construed as showing that they were conspiring to commit a robbery. So there's an additional element there, right? There's continued communication, and then obviously they're out in their car together and with a firearm, right, for the purposes of ostensibly committing this crime, right? So you have all of that. You have plenty of communication to say, hey, we're teammates. Is not, I'm sure both Gonzalez and Espinoza wish that text message never existed, because that's about as close to an objective admission of conspiracy that you can get, right? Teammates were out to get paper, so now we have motivation and clear intent to collaborate. And then we have, you're in the car with a gun on your way to commit a robbery, as evidenced by the fact that you botched the robbery and killed somebody, right? So is that enough to substantiate the conspiracy? Yes, right? I mean, as insofar as we just discussed the definition, yeah, absolutely, right? So based on all the evidence, again, we're back to the rational jury standard, right? The court is not going to debate the decision and whether or not it was the best one. They're just going to say, could a rational jury have come to the conclusion that they did for a conviction under this evidence? And yes, absolutely. That's what the court found. So the attempt and conspiracy multiplicity claim. So this is, again, the claim from Gonzalez on the defense that says that these charges are similar enough, that they're redundant enough, that to convict Gonzalez of both is unconscionable and unjust, that it violates the double jeopardy clause of the Constitution, that you can't be charged with the same crime twice, right? And basically Gonzalez is saying, these are the same thing, right? How are you charging and convicting me and sentencing me based on two different crimes that amount to the same elements, right? So defense argued the conviction for both aiding and abetting the attempt, right, the attempt element, and the conspiracy element arising from the same crime, the same actions, the same behavior, is prohibited by the double jeopardy clause of the Constitution. And so the general rule, when we're relating here to discussing similarity in crimes or overlapping in crimes and double jeopardy, is that two convictions are considered for the same offense if the convictions arise from the same conduct, which they do here, and by statutory definition, there is only one offense, right? So the question is, when we look at the statutes here, is conspiracy and attempt, are they different enough so as to distinguish them from each other for the purposes of separate convictions? And that's really the crux of this analysis that the court goes through. So, in this same vein, defense also argued that both the attempt and the conspiracy crimes were based on the same overt act, which I don't think there's any disputing that. We have that here, that we're talking about the same crime committed the same way by the same people that underpins both of these criminal convictions, right? Thus, punishing both would likely bring multiple counts of conspiracy, where there was one conspiracy to commit multiple crimes, right? So again, if we have multiple crimes here, we're only dealing with a single conspiracy claim because it was for several different things, but you're not going to bring multiple counts of conspiracy, right? So the standard, insofar as we're talking about double jeopardy, the court reasoned back to the Supreme Court's Blockberger test, which goes all the way back to 1932, and basically lays out the framework for analyzing when a case can be brought and convictions can be rendered for two different crimes concerning the same act or set of acts. Right. So the Blockberger test emphasizes the elements of the two crimes insofar as we're dealing with, a claim or an allegation that they're overlapping, and asks a couple questions. Number one, whether each of these offenses contains an element not contained in the other. In other words, when we look at attempt and we look at conspiracy for the sake of the Gonzalez case, can we see something that's different about each of them in terms of their analysis and their reasoning that requires something different that the other one does not, right? That there's a specific element there. If not, according to the Blockberger test, they are the same offense, and double jeopardy would bar them from being concurrently rendered in sentences as concurrent convictions, right? So they wouldn't be allowed, in other words. So the question here is, of course, how did the Supreme Court of Kansas apply the Blockberger test to the Gonzalez fact pattern? So the court looked at the circumstances, and what did they find? They said, although the acts occurred at the same time and the conspiracy precipitated the attempt, meaning the conspiracy was the collaborative effort that brought about the attempt charge, the court held that conviction for both was not barred by double jeopardy. We'll talk a little bit about why. So aiding and abetting the attempt, which is essentially the attempt charge, and the conspiracy are each charged under separate statutes under Kansas criminal law, and each require an element not required by the other, right? So for the attempt part, there needs to be actions that tend to result in the crime with intent to commit the crime, right? So there's a specific intent there, whereas conspiracy is simply attempt to collaborate, right? Not or intent to collaborate, not necessarily intent to commit the crime. So that here again, attempt, you have the overt act and the specific intent. For the conspiracy element, there must be another person involved in the agreement, right? So you can't have a conspiracy claim with just one person, whereas with attempt you can, right? You can have an attempt all on your own. It doesn't need to be anyone else involved, but conspiracy requires that collaboration, whereas attempt requires a certain kind of specific intent that is different by definition than the conspiracy element of specific intent that only requires a specific intent to conspire, not necessarily a specific intent to commit the underlying crime. So it's a little bit different in terms of the way the intent is reasoned. Also, it's important to note that the convictions are for separate crimes, again, under separate statutes, as we discussed. So for these reasons, the Supreme Court in this case said no double jeopardy applies, and the two convictions separately for both conspiracy and attempt are totally proper under the circumstances. So now we move to the jury instruction, right? This is the claim from Gonzalez that says the judge improperly instructed the jury at the trial court level about how they should view the crimes being charged and reason them out in their deliberations, right? So the trial court instructed the jury, and this is on record, right, that a person is criminally responsible for a crime if the person either before or during its commission and with the mental culpability required to commit the crime intentionally aids another to commit the crime or advises another to commit the crime. So that's that criminal complicity, right, element. Also, The person is responsible for any other crime committed in carrying out or attempting to carry out the intended crime if the person could reasonably foresee the other crime as a probable consequence of committing or attempting to commit the intended crime. All right, so this gets us to the felony murder charge, and that's really that's the hinge point behind this alleged erroneous jury instruction. Um, all participants in a crime are equally responsible without regard to the extent of their participation. However, mere association with another person who actually commits the crime or presence at the scene, right, if you just happen to be there, is obviously not sufficient for you to be criminally responsible for the crime. But if you're truly complicit and collaborative and conspiratorial, right, you have a conspiracy and you're part of the attempt, then you will be equally culpable for the crime, right? So what does the defense say here? The defense says intent and conspiracy are both specific intent crimes, and they are, although the elements of specific intent for each are a little bit different. Although felony murder is not specific intent, as we discussed earlier, this is a murder that is unexpected or unintended, but pursuant to the commission of another felony, in this case, robbery. The underlying felony at issue does require specific intent, right? So in this case, we're talking about robbery, or attempted robbery, which is a specific intent crime. So the underlying felony in this case was based on aiding and abetting an attempt and conspiracy. Without specific intent to commit a robbery, attempt and conspiracy would not apply, right? So they're saying specific intent is necessary here. Thus, without specific intent, there would be no underlying felony and could be no felony murder, right? So defense argued that this was an erroneous instruction on those grounds to the jury. It says the jury instruction that the person is responsible for any other involved criminal's attempt to carry out a crime is erroneous because if they lack that criminal intent, the specific intent, the mens rea, then they can't be culpable in the same way, right? So they're saying since attempt is specific intent, person can only be responsible for a co-felon's attempt if they also had that same specific intent. But that was not part of the jury's instructions from the judge, right? So how did the court rule on this claim? The court says, well, the other crimes charged in this case, attempt, conspiracy, and premeditated murder, were all specific intent. And again, I mentioned earlier that the trial court, the prosecution, did attempt to try to make premeditated murder stick. It did not, obviously. So it was a charge, but it was ultimately not rendered and delivered as a conviction. So attempt and conspiracy were, of course, and so was felony murder. The trial court properly described the elements of those crimes to the jury, so there was no disputing that. Felony murder, on the other hand, requires only that the death is reasonably foreseeable based on the commission of a felony, right? So I mentioned this earlier. That's the only requirement for felony murder. You don't need intent. You don't have to show that the person intended for anybody to die. You just have to show that the death part, the murder, was foreseeable in light of the circumstances of what you were doing, right? If you carry a gun into a robbery situation, you should know that murder is a foreseeable outcome, right? That could happen. And therefore, you're responsible for felony murder if it's what happens. Thus, it becomes very important to properly instruct the jury on what allows conviction for the underlying felony. And once you have the underlying felony, the defendant becomes liable for any reasonable foreseeable death, right? So the importance of instructing the jury, the court notes and concedes here, is key. So the instruction given to the jury by the trial court did not distinguish between the specific intent crimes and something like felony murder. So they did not make that distinction, and the Supreme Court noted this. It did not inform the jury which of the crimes was an intended crime and which might have been the other crime committed while carrying out the intended crime. So as such, the jury instruction from the trial court was legally erroneous, right? So there was a problem with it according to the Supreme Court in its certiorari review. However, the court went on to say that this was, in their view, what they call a harmless error. So the court held that the conviction need not be reversed because the error was, according to the Supreme Court, harmless. They said Gonzalez was actually acquitted of intentional premeditated murder, right? Which would have been the concern that if the jury had confused the purposes of specific intent crimes with general intent crimes insofar as the jury instruction was unclear, that he might have been convicted of intentional murder based on the fact that he would be responsible equally for his co-felon's actions. But he wasn't. He was acquitted of that murder, showing that the jury had, in fact, properly understood the difference, right? It had distinguished between crimes where intent was required and intents that it wasn't, and felony murder, obviously, which only requires the foreseeability element. And the prosecution, further in the trial, had argued the aggravated robbery is the intended crime, and the death which resulted as another crime, which did not require intent. So this was discussed in the trial before the jury, which means they were exposed to that information. So the jury likely properly applied the intent requirement to the attempted robbery element because, again, Gonzalez was only convicted of felony murder and not the premeditated. So it was therefore not shown that the jury's verdict likely would have been different had it not been for the erroneous instruction. So basically, the Supreme Court is saying here is that, okay, we acknowledge there was a mistake there, that this could have been more clear, and that the instructions to the jury were legally erroneous. However, it's unlikely that this would have made any difference, right? If we could go back and rewind the clock and correct the statements from the judge, it's unlikely. There's no evidence here that it would have made any difference in the outcome, because it seems from the way that the jury delivered their verdict, the way that they reasoned, that they understood it anyway, right? That it wasn't something that was elusive to them or that was unclear to them. They had that information over the course of the trial, and they actually delivered their verdicts in a way that would suggest they knew that anyway. So the court says, yeah, it's an error, but it's not really consequential in this respect. So now we move to the Fifth Amendment invocation charge, which, again, is the Fifth Amendment plea by Espinoza to avoid testimony in the Gonzalez case. So factually, in order to understand the background, and I talked about this a little bit earlier, Gonzalez wanted to call his co-conspirator Espinoza to testify as to his state of mind on the night of the crime. Essentially, he wanted Espinoza to testify that, look, Gonzalez didn't want to do this, didn't have the necessary mens rea to commit this crime. Maybe he didn't know that it was going to happen, right? Who knows what Espinoza might have offered in sort of defense of Gonzalez. But as I mentioned earlier, Espinoza had already pled guilty and had been sentenced. And so Gonzalez's attorney argued that he should not be able to refuse to testify due to his right against self-incrimination. So basically, normally, if you're being accused of a crime and you're on trial for that, you maintain your right of refusal to testify on the grounds of self-incrimination, because you don't want to say anything that could lead to your conviction. But the attorney for Gonzalez says, well, Espinoza's already been sentenced, like he pled guilty, and that's over. So what is it that he would have to risk by testifying on Gonzalez's behalf? But Espinoza's attorney argued that Espinoza did in fact have something to lose. He said that he didn't want to testify because he was still pursuing the sentencing appeal, and the confession could hurt that appeal, right? So he's trying to overturn his conviction. And again, the confession that he gave could ultimately damage his chances of overturning that if it's on record in the Gonzalez case. And he was also trying again to withdraw his guilty plea for the sake of overturning his conviction. So all of that could be affected by something that Espinoza says in the Gonzalez case, which is why he pled the fifth. So when debating whether testimony should be allowed, the proposing side must proffer what the testimony will be to allow the court to make a decision. And there was, in fact, a proffer at the trial court level about what Espinoza would put forth. So Gonzalez's attorney told the court at that time that he would be asking questions regarding what Espinoza observed that night as regards to his defendant, meaning Gonzalez, not what Mr. Espinoza did. So again, Gonzalez's attorney's angle was, I'm not interested in what Mr. Espinoza did because we're not litigating his sins in this case. We're concerned with Mr. Gonzalez. So all I want to ask questions about of Mr. Espinoza is, what did he know with respect to Gonzalez's state of mind and his extent of participation in these acts, right? That's what's key here. So Gonzalez's attorney argues that therefore there's no need to worry that Espinoza would incriminate himself. But of course, Espinoza and the prosecution, which, for obvious reasons did not want Espinoza to testify in Gonzalez's defense, argued that Gonzalez would need testimony about possible illegal drug use by both people, which could hypothetically hurt Espinoza. And the court agreed, reasoning that Espinoza's testimony could not be limited in such a way that it could be assured, right, that it would definitely not hurt him in his appeals, that there would be no way to sort of separate those two subjects in such a way that we could assure that Espinoza wouldn't be exposed to saying something that would potentially be damaging to him later on. And therefore, there was a Fifth Amendment interest there in not self-incriminating that needed to be protected. So there was no other discussion outside of this brief proffer about Espinoza's potential testimony. It was very brief, and there wasn't any further deliberation as to what might have been said and how it might have been said, and in what ways tangibly it might have helped Gonzalez's case, because we really don't know, right? Without the testimony, we really don't know what Espinoza would have said. So the application, insofar as we're concerned with the proffer and the idea that Espinoza should have been forced to testify, what did the Supreme Court say? They said there's no sufficient record about what Espinoza would have said. Again, this was not thoroughly worked out at the trial level. There wasn't any solid deliberation as to what would have come forth. And for a reversal, the Kansas law would require evidence as to the substance of the expected evidence. In other words, what do we think that this person would have said that would have changed the outcome, right? Is there any evidence to suggest that there would have been such testimony that would have been significant in that way? The proffer was made in an informal setting, in this case, a bench conference, and there was no written motion or details about the testimony. So there's no record there to indicate what it would have been and how significant it would have been, if at all. Even if the proffer established that Espinoza would have said Gonzalez smoked marijuana or took a Xanax, right, insofar as it might negate the state of mind, there's nothing else about any other potentially relevant details that Espinoza's testimony could provide, such as, again, how much drugs, when they took it, what specifically he observed about Gonzalez's behavior or his participation in the crime that might have exonerated or at least limited the liability of Gonzalez. So all of those facts, which might have been useful, it's totally unclear as to whether or not Espinoza would have had anything relevant to offer at all. So the proffer was thus insufficient to allow this issue to be reviewed on the appellate level. And so we come to the Batson challenge, Batson v. Kentucky. Again, in the Batson case, this is the jury peremptory challenges that we discussed early on, and the use of peremptory challenges for racial discrimination purposes. So the Supreme Court in the Batson case forbids prosecutors from challenging potential jurors, even in peremptory challenges. So again, as I mentioned earlier, it's important to sort of distinguish. Most of the time, both sides in a criminal case will have the right to strike jurors for cause, and they'll have so many of their for cause strikes, but they'll also have some peremptory strikes, which means that they don't have to put forth a reason or a cause on record. And so what this is saying is that it forbids prosecutors from challenging potential jurors, even in the peremptory challenges where you normally would not have to put forth a cause, solely on the basis of race or on the assumption that a jury could not be impartial due to his or her race, right? So it doesn't allow that even for those peremptory challenges. It specifically forbids it, right? And so what Gonzalez is saying in this appeal is that the state exercised challenges to systematically eliminate Hispanic jury members that would share the same ethnic persuasion or ethnicity. As Hispanic, the quality of being Hispanic is defined under our census and our federal laws as an ethnicity as opposed to race. But for the purposes of this discussion, they're one and the same, right? So what Gonzalez is saying is you wouldn't let any Spanish people serve on the jury, and you struck them for the purposes of eliminating Hispanic sympathy, right? And any type of someone to relate to Gonzalez on the level of sharing a common heritage in that regard. So he's saying that was illegal pursuant to the Batson case. Determinations of the trial court in this regard are reviewed based on the abuse of discretion standard, right? So in other words, did the prosecution abuse its discretion in striking jurors? So there's a 3-step process with Batson under which a challenge, an allegation that there was some wrongdoing has to be looked at. And this is what happens here. So first, the party challenging the strike has to make a prima facie showing, meaning, on the face of the evidence, that the other party exercised a challenge on the basis of race, right? That's the crux of this whole claim. So the party challenging here, of course, is Gonzalez. So Gonzalez has to show with clear evidence that the prosecution made peremptory strikes for race, for the purposes of excluding race, right? Number two, if supposing that that's accomplished and that Gonzalez meets that hurdle, the burden shifts to the party exercising the strike, which would be in this case the prosecution, to articulate a race-neutral reason for striking the prospective juror. right? And the reason offered will be considered race neutral unless a discriminatory intent is inherent in the explanation. And you're seeing sort of, you should be recognizing sort of an open-ended, giant opportunity that admits of a tremendous amount of subjectivity here, right? Because imagine you're a prosecutor who is accused of having committed this wrong of having stricken jurors from your jury pool on the basis of race. And so let's suppose that the defense satisfies step one and they show some evidence that says, well, look, there was juror number 1 and 3 and 7 and 9 and 14, and they were all Hispanic and you struck them all. So how do you explain that? And so the judge turns to you in step two and says, what was your race neutral reason for striking the prospective juror? And as a prosecution, you need only articulate any reason that isn't racially charged, right? You can see here, and we'll talk about what the prosecution's proffered reasons were. And I'm not suggesting in our discussion here that these reasons were illegitimate or dishonest. I'm just saying that you can see how this is an uphill battle for anyone that is alleging wrongdoing in the striking of jurors on the basis of race, because the prosecution need only put forth any conceivable race neutral reason, and it is under the Batson test virtually guaranteed to be accepted unless there's some sort of racial hinge point. So as long as you just steer clear of that in your explanation as a prosecutor, you're almost given a blank check here. So it's a very hard case to prove. And then step three, of course, the court determines whether the opponent has carried the burden of proving purposeful discrimination. So they look at the balance of the two claims to determine whether there's something there, there's some meat there. So the final step hinges on the credibility determinations, because usually, again, this is what I was just speaking of. There's limited evidence on the issue, and the best evidence is often the demeanor of the party exercising the challenge. So looking at the prosecution, right? What was their motivation? What can we infer from what they did and how they did it to suggest that there was, in fact, some nefarious motive to exclude people based on race? But that's very hard to prove, right? Unless the prosecution stands up and admits it. If they give any other reason at all, it's very hard to prove that that's an underlying reason, supposing that it is, right? Even if it is the underlying reason, how do you get to that, right? As opposed to any other reason that would be put forward as just a facade for, a racially motivated motion to strike a juror. So, and I'm not saying this happens, in a proliferated way ubiquitously, or that it should happen. Obviously, I'm just saying that it's a very difficult thing for defendants to prove when prosecution improperly strikes a juror. So in this case, 3 Hispanic potential jurors were struck by the prosecution. The first, juror 34, which was a young female student with no job and 1 arrest. The prosecutor said that he struck her because he prefers jurors who are married, who have long-term jobs, and who have children. And so you listen to these answers, and again, you sort of see what I was saying earlier, is that these are reasons that could be entirely fabricated, but they're also theoretically plausible, right? They do make some level of sense. They're not completely arbitrary and don't seem to have any tie to a motivation that a prosecutor would have. Why would a prosecutor want someone who is married, who has children, who has a long-term job? Well, they want someone with substantial ties to the community, right? So that there's an investment in the community in which they live, and the need for law-abiding citizens and peace and order, right? So these are things they care about, mature values of someone who has a family, especially people who have children, right? And then they empathize with victims, and they think about, well, what if that person who was killed by this assailant was my child, right? Can you appeal emotionally to someone who has children in a way that you can't to someone who doesn't? Perhaps, right? And so you may agree or disagree strategically with these reasons for the prosecution, but you can't deny that these are at least conceivably legitimate reasons from a strategic standpoint for a prosecutor to want to strike a juror, right? That these are reasons that would make sense depending on what you're looking for in your prosecution strategy, right? Juror 39, an employee of a community mental health program. And again, prosecutors said here that working with mental health patients could create a pro-defense bias. So again, an ostensibly rational reason, even if it's not the real one. And I don't have any evidence to suggest that this prosecutor was being dishonest. But think about it. Why would you want to strike a mental health professional? Well, if there's some reason to believe that Gonzalez or Espinoza or both were suffering some kind of mental disorder that could lead them to, do something like this. In other words, a pity element, a sympathy element with the criminal accused, because you say, well, we'll pour them in their unfortunate circumstances of their poor mental health or their drug intoxication that led them to do something, and to perceive the incident as not a product of pure motivation and independent free will, right? If you will, ignoring scientific debate over free will, to say that again, that this is a choice versus an affliction of a mental malady, and so you could see a reason why a prosecutor would want to strike a mental health community professional, right? And then finally, jury 44, a multiracial Hispanic who's young, single, and had a job for less than a year. And again, the prosecutor basically cited the same reasons as the first one, that this person was struck because he prefers jurors who are married, have children, and long-term jobs, right? So what does the defense say in response? Gonzalez argues that, again, the first did have a job as an administrator. The second was middle-aged and had strong community roots. And number 44, the third one, lived in the community her whole life and was employed as a bank teller. Right. So this is evidence that Gonzalez is putting forth to rebut the purported reasons that the prosecution is saying this is why I chose to strike this person. Gonzalez pointed to some other non-Hispanic potential jurors who are young, single, had criminal records, and less education, and yet were not struck. So basically, Gonzalez said, well, look at all these other people who happen to not be Hispanic, but who didn't meet the criteria that you yourself said were the reason why you struck these people, and yet you didn't strike them, right? You chose to keep these people in. Why? Right. So though there were many non-Hispanics that were struck by the prosecutor. So it's important to note that in addition to Hispanic people, it's not as if the prosecutor only struck Hispanics. It's that there were Hispanics that were included in the jurors that were stricken by the prosecutor. Right. So that's worth noting in context. Thus, all the reasons, according to the defense, given that we just discussed, as I mentioned earlier, as a possible strategy for a prosecutor, were pretext. They're alleging that essentially that this is nonsense, that it's BS. That all of this is just a thinly veiled facade, an illusion to cover the fact that you excluded them for racial purposes. That's the allegation, right? So what did the court say in response to this sort of back and forth? First, the court says comparisons to jurors who were not stricken is a poor basis for attacking the court's decision because the judge is not required to compare information elicited from all the panelists. So in other words, they don't have to look at all the people who are not stricken because that opens up a sort of never-ending can of worms here. And so that's not a good basis under which to argue that there was unfairness here. As for the three jurors, this is the court's interpretation. They said juror 34, the first one, did have some education, but overall had a perceived lack of investment in the community. So they're basically saying that the prosecutor's purported reasons are at least conceivably legitimate. Juror 39 was the only potential juror that works in mental health, and the prosecutor's concern had not been shown to be a pretext for racial discrimination. They said, this makes sense, at least in principle, and there's no evidence that we have to suggest that this is just a facade for racial discrimination. So we're fine with that as well. And then thirdly, the juror 44 had low community investment, and in fact, two white, one Asian, and one African-American juror, all of these individuals were struck for all the similar reasons. Right. So again, we come back to the point that the prosecution also removed other jurors from the pool for the same reason that happened not to be Hispanic, which would go toward the idea that these were not racially motivated. So this is the way the court reasoned. In essence, the trial judge's ruling the prosecutor's reasons were not shown to be pretext for racial discrimination was within the judge's discretion. And again, the Supreme Court was disinclined to Monday morning quarterback the trial judge's discretion so long as it was rational, right? And again, here they determined that it was, right, that it conceivably made sense. So concluding the outcome of the Gonzalez appeal at the Supreme Court of Kansas level, what did they find? They found the evidence was sufficient to show the specific intent necessary for both attempt and conspiracy. They found that aiding and abetting the attempt and the conspiracy claim had different elements, and therefore they didn't violate double jeopardy to charge and convict and sentence on both. They found that there was, in fact, an error in the jury instructions, to be fair to Gonzalez, but that error probably didn't have a big effect, if any, on the outcome of the trial and the verdict, and therefore it was deemed to be harmless. They found that the allowance of Espinosa's refusal to testify under the Fifth Amendment could not be reversed because there was an insufficient proffer as to what he would have said and whether or not it would have made any difference at all. And in fact, he did have sort of skin in the game insofar as his Fifth Amendment claim was legitimate, because he could have, in fact, done himself harm in his appeal of his own conviction and his walking back of his confession. And then finally, the Batson challenge, insofar as it concerns peremptory challenges for racially motivated reasons, was denied because there was insufficient showing that the prosecutor's reasons for striking the Hispanic jurors were just pretext for racial discrimination. Right? There was not enough to substantiate that the purported reasons the prosecution gave for the strikes was illegitimate or dishonest or false and fraudulent. And so that concludes the analysis of the Gonzalez case. This was, again, an interesting one with, as usual, a lot of moving parts, a lot of different claims, a lot of careful analysis, and important tests that come into play in determining, which claims are meritorious and which are not. But this is an interesting criminal case that outlines many of the common appellate procedures that are undertaken when a convicted criminal appeals the conviction and attempts to have things overturned. So hopefully this was useful to you. I appreciate you listening to this video, and I'll see you next time for another great one. Take care, everyone.